Welcome to Unit 7. In Unit 7, we're going to focus primarily on the regulatory process of how a well gets drilled. And so we're going to take a close look at the Oklahoma Corporation Commission process and how operators in this state go through the regulatory process to get a well drilled. And so we're going to talk about the creation of a drilling and spacing unit, the pooling of a particular drilling and spacing unit, filing an intent to drill, the permits, completion reports, everything that kind of goes into the drilling and completion of a well from a regulatory process here in the state of Oklahoma. It's important to note that pretty much every state has some sort of regulatory process. Any state that has oil and gas production has some sort of regulatory process that oversees the development of oil and gas within that particular state's borders. But due to time constraints and obviously there's a whole lot of states to cover, we're going to focus primarily on Oklahoma today in lectures 1, 2, and 3 here of Unit 7 and kind of do a walkthrough of the Corporation Commission process here in Oklahoma. So excited to do this. Let's get started and we'll jump right into the creation of a drilling and spacing unit in Lecture 1. Thanks. Now, if you'll hearken all the way back to Unit 1, we touched a little bit on conservation laws and what the purpose of conservation laws were kind of during the infancy of the oil and gas industry as it was kind of starting to expand and turn into the viable industry that we know today. Now, the Corporation Commission is basically the statutory body, and it's actually a constitutional body in the state of Oklahoma. It's written into the Oklahoma State Constitution that basically oversees all conservation laws as it pertains to oil and gas anyways, in the state of Oklahoma, in the statutory process and administrative process that a party must go through in order to be granted permission to drill an oil and gas well on your leasehold or perhaps on your minerals on any property that you may control or have a right to be there. So the first step of that is the creation of a drilling and spacing unit. Now, before we get into the specifics of how we create a particular drilling and spacing unit, again, it's important to note that conservation laws are basically created to do a couple different things. And this is always something that as an oil and gas commission attorney that practices in front of the Corporation Commission, you kind of have this phrase drilled into your head because it's pretty much how you sign off on each one of your regulatory hearings out at the Corporation Commission. But what we're trying to achieve here with regards to these different types of conservation laws are to protect the correlative rights of all the parties that are involved, to prevent waste, both economic and physical waste, and to promote economic development. So, with regards to conservation laws, that's kind of the trifecta that we're hoping to achieve by either asking permission from the Corporation Commission to drill a well or create a spacing unit of this size, of this magnitude, of this orientation. And it's an opportunity or the goal, if you will, is again kind of three-pronged. It's that we hope to protect the correlative rights, to prevent waste, and to promote economic development. So that three-part phrase is something that you'll always want to remember with regards to the Corporation Commission here in Oklahoma, but pretty much any regulatory agency or the whatever administrative body that oversees oil and gas development in whatever particular state that you're going to be practicing in or working in throughout your land or legal career. Now, normally the first step in getting a well drilled in the state of Oklahoma is getting a drilling and spacing unit created. And that's what we call it here in Oklahoma. It's a drilling and spacing unit. Now, you'll hear it referred to in Texas and some other states as a proration unit or a production unit or whatever it might be. But it's basically a designated area that one well should economically and efficiently drain. And so oftentimes the size of the unit, drilling and spacing unit or proration unit that you'll see in Oklahoma, in Texas as well, is normally, it's going to be smaller for oil, again, because we think about the physical differences between oil being, it's oftentimes a thick, viscous liquid, and then gas being a vapor. Obviously, one is going to have more viscosity, if you will, than the other. And so oil normally drains on a much smaller pattern, and we always assume radial drainage patterns with regards to the regulatory agency, although that's probably not how most wells drain. But oil wells oftentimes will be set up on 40 acres, 80 acres, and perhaps maybe even 160 acres in some of your larger drilling and spacing units created for vertical wells for the production of oil. Now we contrast that with gas wells, which again, just through physics and the physical distinction between oil and gas is going to drain a much larger area. Typically your gas drilling and spacing units are either going to be 160 acres, 320, or 640, which is basically an entire section of land under the Jeffersonian or section, township, and range types of surveys. So, and that's typically what we see in Oklahoma, is that most parties will ask for the largest drilling and spacing unit that they can geologically and technically put forth the evidence to get created by the Corporation Commission. So our request from the Corporation Commission to create a particular drilling and spacing unit is basically we're going to be putting forth evidence that states, OCC, we believe that one well will effectively and efficiently drain this area, and whatever that area might be. Again, 160 acres, 640 acres, whatever it might be. And so what we'll do to start this process is to create an application, and it's basically a written form to the Corporation Commission that states we're hereby asking permission to create 640 acre drilling and spacing units for production of oil and gas from the Woodford or the Mississippian or whatever common source of supply or geologic zone that we're interested in testing. And then what we'll do is create a respondent list that goes along with that and send notice to everyone that owns an interest in the oil and gas estate in that particular designated spacing unit area. So again, if it's 160 acres, we're going to send a copy of that application and notice to everyone that owns in that 160 acres, or if it's 640 acres, we're going to send a copy of that notice in the hearing to all owners within that 640 acre section. So everybody that's entitled to basically receive a part of the proceeds is who we will notify through a drilling and spacing unit application. And so we'll set a hearing date with the Corporation Commission, normally 2 weeks, 3 weeks after you send out your application or file your application with the Corporation Commission. And basically we do that for due process purposes. So everyone is entitled to notice and a right to attend the hearing whenever we're doing something that's going to affect your property rights. And again, we deem the ownership of oil and gas rights in most states as an interest in real property, and so we're going to send them a notice and a copy of the application, and they have every right to show up and attend the hearing and listen to the testimony and the evidence that's going to be put forth. Again, for whatever reason, the vast majority of owners of oil and gas rights in the state of Oklahoma, at least mineral owners, choose not to show up, and that's fine. They don't necessarily have to, but the oil and gas companies that are typically involved or typically put on notice will have some representative there or have an attorney there that's going to be representing them in most of the regulatory hearings that's going to affect their particular interest. So typically in a drilling and spacing unit hearing, we'll put forth either a geologist or a reservoir engineer, some sort of technical witness that will testify as to the existence of that common source of supply, i.e. the Woodford zone is present in this section, and we typically show that via logs, well logs that show the depth of the particular zone we're talking about, or perhaps we have seismic data or geological geophysical data, whatever we might have, just some sort of evidence that shows the zones that we're expected to encounter are there. We expect to encounter them at this depth, and we believe that one well will drain this size, again whatever size of the drilling and spacing unit that we choose to put forth. And typically in Oklahoma, whenever we create a drilling and spacing unit of a typical size, let's say for 40 acres, 160 acres, 640 acres, whatever that size might be, there is a legal area within which to drill the well. And that's normally the center of the square, if you will, center of the drilling and spacing unit. The centermost 20 acres within a 40 acre unit, the centermost 80 acres within a 160 acre unit, or the centermost 320 acres of a 640 acre unit. But what happens if we want to drill outside that particular designated or legal location, if you will, under whatever drilling and spacing unit size that we choose to ask permission from the commission for? Well, typically what happens is that we have to get what's called a location exception. In the state of Texas, oftentimes you'll hear these referred to as either Rule 37 or Rule 38 exceptions. But in Oklahoma, it's typically called a location exception. So let's talk a little bit now about what a location exception is and how it ties in to a drilling and spacing unit. Okay, so we've went through the process of getting a drilling and spacing unit approved from the Corporation Commission, and thus they've granted us our spacing order, is oftentimes what the final product we're seeking through the Commission is going to be. But for whatever reason, perhaps it's some sort of surface impediment, i.e. a pond or a lake or a housing addition, whatever it might be, we cannot physically place the well inside that box, if you will, that legal location box, and thus we need permission from the Corporation Commission to drill outside of a legal location, which oftentimes you'll hear it referred to as an off-pattern location. And so again, could be surface reasons as to why we can't do it. Again, some sort of a grove of trees or orchard or whatever it might be, or it could be some sort of subsurface issue as well. Let's say that there is a fault that's kind of running through the middle of the section, and thus we need to be closer to the north half of the section or the south half of our drilling and spacing unit. Again, whatever sort of geological or surface reasons there might be that would force us to place the well outside of a permitted or a legal location. And so the process with regards to a location exception, again, is very similar, and you'll see that for all applications that you file with the Corporation Commission. You'll file an application asking permission to drill the well at an off-pattern location. Normally you'll be required to state the footage as to where that location is going to be. You'll set a hearing date, and then you'll give notice to all the parties that are required notice. And with regards to a location exception, it's usually the parties that you're encroaching upon. So let's say, for instance, that we want to drill our well closer to the north line of our drilling and spacing unit. That's outside of the prescribed or legal footages. And so what we would have to do is notify all the parties in that in the section to the north of us that we're moving our well closer to. And this is basically for drainage purposes, right? So again, we think back to Unit 1, we think back to the rule of capture, we think about the migration of oil and gas, how it's fugacious, and it basically moves freely, if you will, in the subsurface. And so if we're moving closer to someone's a section line or boundary line, then in essence there's a possibility that we could be draining oil and gas from underneath their lands as opposed to just the lands that we're going to drill the well on. And so we're required to give those parties notice. And oftentimes they may have a problem with it, as you might expect. And so they'll show up, protest, and state, well, look, we don't want you to drill the well here. We want to move it further south. And then basically it becomes a kind of a court hearing, if you will, as to both sides will put forth evidence to state that, well, this is why the well needs to be placed here. The party that is getting encroached upon might state that, well, there's actually a legal location on the south half of the unit that they haven't explored or whatever the facts of the case might be. And so, again, we're required to give notice, due process, an opportunity for everyone to be heard whenever we're dealing with interest in real property that's owned by parties in that section or in that surrounding area. And so if the facts are on the applicant's side, i.e. there is some sort of surface impediment or subsurface geological reason that dictates that the well needs to be drilled in an off-pattern location closer to one unit boundary or another, you'll get your location exception order granted, and then you'll be allowed to go drill that well in an off-pattern location. But again, goes through a similar process. We file an application, we ask for permission from the Corporation Commission, notice of the hearing. All parties that own an interest are allowed to show up and put forth testimony should they wish to do so, and that's the process of getting a location exception granted. And so that'll conclude Lecture 1 of Unit 7. So again, we're diving into the regulatory process of how a well gets drilled in the state of Oklahoma in particular, although there's a lot of similarities in other states' regulatory agencies as well. So we started off our conversation by defining what a drilling and spacing unit is, how we create one, what it's utilized for, and then we jump to a location exception, which is basically an application for permission to drill a well outside of the prescribed parameters of the normal drilling and spacing unit of that particular size. And again, talked about some of the reasons as to why that might be the case, some sort of surface impediment or reason as to why you can't place it where you want to, or perhaps there's some sort of subsurface or geological reason as to why you want to be closer to one unit boundary or the other. So in Lecture 2 of Unit 7, we'll jump into the pooling process, and now that we've established our drilling and spacing unit, and we perhaps have got a location exception if we need one, now what's the next step in getting the well drilled? We're going to pool it, and we'll talk a little bit about what that means in Lecture 2. So thanks again for the time, and we'll see you in Lecture 2.